single family or a condo townhouse property that's listed for sale or lease, then that's why you can have that second listing in the rental section of the MLS. Such listings are likely to be listed subject to the agreement to procure tenant that Stephanie talked about, which is the new addendum that came out this past year for those types of properties. And as she said, it does have to be used with the North Carolina Association of Realtors Standard Form 101, which is the exclusive right to sell listing agreement. Those two forms have to be used together in conjunction. As with all listings in the MLS, member participants and subscribers must disclose in the listing if they are the owners or have an ownership interest in the property that is submitted to the service. The other property categories for Tempo have a field called agent owner equals yes, no. So if you are the listing agent and you also happen to own the property, you would choose yes in that field. The rentals category doesn't have that field for some reason. So in order to satisfy this requirement, you would have to put a statement in the agent remarks that indicates that the agent is also the owner of the property that's being offered for rent. And then also, as with all listings, subscribers must sign an agency agreement with the listing brokerage when listing their own properties in the MLS. So if you are listing your own property and you work for a brokerage, you're not a broker in charge, you do need to have an agency agreement on file between you and the brokerage in order to list that property in the MLS. And as Stephanie touched on in her presentation, there is no standard NCAR form for listing a residential rental only to find a renter without also acting as a property manager. So what are you going to do if you don't have a form? Well, you need to proceed with caution. Realtors who are property managers do caution that such listings pose a risk of potentially violating the Realtor Code of Ethics, as Dana very well explained how that can be a problem. So if you don't have a form, you could ask an attorney to draft an agreement for you if you do choose to pursue that route of listing a property without also being a property manager. The North Carolina Real Estate Commission and the North Carolina Association of Realtors sometimes indicate that Commercial Form 572, the exclusive right to lease listing agreement, which is a commercial form, can be used, but it's not designed for residential rental listings. So we would just caution you that if you use that, then sort of do that at your own risk, because there could be problems with that. A residential rental listing only to find a renter is considered a limited service listing. So if you are referring prospective tenants back to the owner landlord, and they're going to do everything like take applications and negotiate the terms of the lease, we would consider that to be a limited service listing. So there is a field for that in Tempo. It's called full service equals yes, no. The default is always yes. So if it is a limited service listing, you need to click no in that field so that other brokers know that they could be in a position of having to contact the landlord or the owner directly if they're representing a potential tenant. And then finally, let's talk about cooperative compensation. So this is one of the biggies. As with all listings in the MLS, including lease purchase and rental listings, you must offer cooperative compensation on every listing that goes into the MLS. And that's because cooperating brokerages have a right to know what their compensation will be prior to their endeavor to sell or lease a property. The way that compensation has to appear, it can only be in two forms. It has to be either a percentage of the gross sales price or a set or fixed dollar amount. Payment of cooperative compensation depends upon the sale or lease of the listed property. And that can be an issue, as Frazier mentioned, because in the MLS, the rules require that it's basically the sale or lease of the property that triggers the payment of the compensation. So if you're in a lease purchase type situation and you are trying to recover some of that compensation at the inception of the lease rather than waiting until 1 or 2 years down the road for that property to actually close, if it's not mentioned in the listing, which some agents will do that, some agents will put that half of the first month's rent will be paid as a commission, or you might see half of cooperative compensation paid at inception of lease, remainder paid at closing. Sometimes you will see statements like that in the agent remarks of a listing for a lease purchase, but if you don't see something like that in the listing, then you do need that up front and negotiate that before you present the offer, so that you are taken care of as far as your compensation as a representing buyer in that situation. And now for rental listings, cooperative compensation often appears as a set or a fixed dollar amount. That's typically what we see. We often see compensation expressed as a percent of the first month's rent. That's common. And then there are other things that we've seen in there as well. I mean, sometimes it might be based on the first 2 months rent, or the first 6 months rent. It can vary. So, but as long as it's either somewhat akin to either set dollar amount or a percentage of the rent price, something that you can figure out what your compensation will be, then they've met the requirement of the CMLS rules. So thank you for your attention, and Lynn, will you help us with our Q&A?
So that everyone can hear your question and direct it to one of the panel members. Is that mic on? Is that?
Yes, ma'am.
Okay, and that mic is ready for you. So, first of all, I would just like to say what a great panel we have here. Thank you very much. Also, would you state your name and who your question would be for?
My name is Robert G. I'm with TKH Realty. I have a question for Frazier. You were saying at different points, buyers' escrow money or buyers' option money could kind of be up for grabs if the seller defaulted in some way. Is there a way to escrow that money?
Yeah, I don't see a reason why you couldn't. The reason the seller wants that money is because it's being paid as the seller's taking the property off the market. So they want to be paid some sort of compensation that says, hey, look, I've got this money now. If this thing closes 2 years down the road, I'll credit it back against the purchase price. They want that money. They want to spend that money as soon as they get it.
Since it's going to be credited back with the purchase, so I was thinking that maybe it should be escrowed.
It could, yeah, absolutely. Or you could just show a purchase price reduction for that amount, and that's usually what I see. Yep. Thank you.
Hi, I'm Sandy Byrd. Okay, I have two questions for you.
Sure.
One has in regard to the commission, because you have down here that it would be included possibly in your agreement.
Sure.
I thought we were to keep commissions out of any kind of an agreement.
Well, the way
we have that company, company to company.
Sure, sure. Well, the way I've drafted it a few times, maybe once or twice, is where there's a paragraph that says, okay, listing agent for bringing this deal together is going to get a portion of the first month's rent or an amount equal to as kind of compensation for bringing this together. And then if it's a portion of the commission is going to be paid at closing. You might get if your total commission is 3% as a listing agent, then you might get 1.5% at the inception of the agreement. And this has all got to be taken care of up front and negotiated out as long as you get forward with it. And then the other 1.5% closing down the road.
But you're saying it's legal to have a requirement